Hello everybody, it's your immigration attorney Luis Ruiz here with you today with bringing you a new video on our VAWA series. Now, as you might know by now, VAWA is the Violence Against Women Act. It was enacted by Congress to allow people who have been victim of domestic violence, extreme cruelty, or physical abuse to obtain lawful status in the United States. The program is open for parents, children, and spouses of United States citizens or permanent residents. Today we're going to talk specifically about children and how children of permanent residents or United States citizens can obtain lawful status if they've been victims of abuse. Now, one very important thing that we need to discuss is that the abuse that you suffered at the hands of your parents, U.S. citizens or permanent residents, must have happened before you turned 21 years old. So if your parents started abusing you at the age of 22, no longer qualify. The abuse must have happened before you turn 21, You must, in order to apply, you must be unmarried and under 21 to be able to apply for the program. There is an exception that you can apply up until you're 25 years of age, but only if we can prove that the delay in filing, because the regular rule is that you have to apply before you're 21, but we give you 4 more years to file to 25 if we can prove that the reason in the delay was because of the abuse, that either you were still being abused and weren't able to apply, or that maybe you were so traumatized or so affected by the abuse that you weren't able to apply. In no circumstance can you apply after the age of 25. The rule is you have to apply before 21 or before 25 if we can prove that the abuse was the reason why you didn't file before you were 21 years of age. You must have resided with your U.S. citizen parent or lawful permanent resident parent, and you must be a person of good moral character. You must be a good person. We want you to be here, but you have to be a good person. Now, the government recognizes in a lot of these situations that the abused person will have immigration infractions or criminal convictions or infractions because of the abuse that they're suffering. So if you have an immigration violation or a criminal conviction or a criminal record, as long as we can tie that conviction or that violation, the immigration violation, to the abuse that you've been suffering, then the government will be able to waive those infractions in order to allow you to become a lawful permanent resident of the United States. So you must apply before you're 21. Parent must be a permanent resident or U.S. citizen. Can apply before 25 if we can prove that the abuse was the reason in the delay. You must have lived with your abuser, parents, and you must be a person of good moral character. If you have criminal convictions or if you have an immigration infraction, we can waive them again if we can tie that behavior, those infractions or the conviction, to the abuse that you were suffering. So that's how a child can obtain lawful status if they've been victims at the hands of their parents. Now, a lot of the time we don't know when domestic violence is happening in a home. It's something that we as a society don't speak about enough. So please share this video to your social medias, like our video, subscribe to our video, and share it because we don't know who's suffering. We don't know who might need this help. Because this subject is so taboo, there's people in our own family, in our own circles that suffer from domestic violence and we don't even know about it. So please share this information. Let's get it out and help as many people as we can. Thank you.